aren't screaming, just so you know. Testing 1, 2, 3, 4.
Thank you.
Testing 1, 2, 3, 4. Testing 1, 2, 3, 4. Testing Justice 4. Testing Justice 3. Testing Justice 2. Testing Justice 1. Testing podium. Testing lavalier. Very loud lavalier. Podium. Testing plaintiff lavalier. shall be heard.
Good morning. You can be seated. The first matter that we have this morning is Penobscot 25318, State of Maine versus Jeff Belony. I see counsel are present. I'm assuming ready to proceed. We are being streamed on the web, both by audio and by video. If counsel would introduce yourselves to start by saying your name for the record, together with the party you represent, starting with the appellants.
Yes, good morning, Your Honors. I'm Hunter Tavares. I'm representing the appellant, Jeff Belony.
Good morning. Jason Horn for the State of Maine.
Thank you. And Attorney Tavares, if you are ready to proceed, we'd be happy to hear your argument here this morning.
Yes, thank you, Your Honors. The stop of this vehicle was not supported by reasonable suspicion. The basis was that the officer indicated the plate was obstructed, but the officer could read the license plate number when he was behind the vehicle, and the purpose of that statute is for the police to be able to identify the registered owner, which they previously did reading the license plate of that vehicle when it was at the bus station. So the stop was not supported in this case. The court doesn't need to go any further. But if you did, once the stop was conducted, the mission of that stop was to write a warning for an obstructed plate, but the real mission was really to delay this stop for several minutes in order for a backup officer to come so the K-9 unit could be run around the cruiser. Around the vehicle Mr. Belony was in. And that's apparent from all the officer's actions. When he first pulls the vehicle over, he doesn't even get out at first to talk to the driver. Instead, he spends 30 seconds talking to an MD agent on the phone about their investigation.
Counsel, I see that the green light is on. Can I go back to the plate light or the plate issue? I mean, the issue for reasonable articulable suspicion is not that he in fact committed the violation, but that there was at least a reasonable articulable suspicion that he was in violation of the statute. Given the obscure, you can argue about how far away you could be to see it, but it was obscured, and to some extent, isn't that at least a reasonable basis to stop?
No, not in this case, because the officer could read the plate before he stopped it, according to his testimony in the transcript. And the purpose is that it's plain and visible. The legislature doesn't set at what distance it needs to be plain and visible.
Well, the legislature sets at what distance in another statute, which requires a plate light to make sure that the characters on the plate are visible for at least 50 feet. Should we look at that?
Not for this case, because if the legislature intended that to be for the visibility of the plate during the day, it would have included that in the statute, as it did with the plate light.
Can we look at the surrounding statute to try to get a sense of what the legislature intended in this circumstance? It's part of the same.
I understand where you're coming from, Your Honor, and even if the court was to go there, the 50 feet here, the officer was 50 feet off his bumper and could read the plate at that time, so there's at that moment no basis for reasonable suspicion. But this is even different in this case because the officers saw that vehicle, minutes before at the bus station. They read the plate. That's how they got.
That was the front plate, though, right?
Correct. But the purpose of the statute is to be able to identify who's the registered owner of the vehicle, which they were able to do.
You said the officer could see it from 50 feet away? What is the basis for saying that?
I can't say exactly 50 feet away. You said when he was on the bumper.
Okay.
Or close to the bumper of the vehicle. So the record doesn't establish the distance at that point, Your Honor.
Was the seatbelt an additional basis for the stop?
Not according to the lower court in its decision. It found that not to be essentially a credible basis for the stop and rejected it.
Can we move on to the delay that you're claiming took place during the stop itself? As I understand it, correct me if I'm wrong, the court concluded that the delay when Officer Libby is seated in the cruiser added about 5 or 6 minutes, but in fact, I believe it was actually 7 to 8 minutes. Am I correct on that? The actual time when Libby is in the car?
Yeah, I can address that, Your Honor. The lower court did say 5 to 6 minutes, which I think is just a clear factual error that I don't even believe the state disputes. The state said 8 minutes and 48 seconds, I believe, and it's in its brief that before Mr. Belony would have been identified at the earliest.
So what do we make of the fact that the court's decision that it was not an unreasonable delay was based on 5 or 6 minutes, but if in fact it was actually longer, can we on the appellate court simply say, well, that's not much longer, and therefore it's still not an unreasonable stop or a delay?
I think any delay is unreasonable according to Rodriguez if it's beyond the scope of the mission here to write the ticket for the obstructed plate. I mean, you look at the record, you could, and actually here we have a recording of the officer in the vehicle for over 5 minutes after he
But
got
I think the court felt, and it was suggested by the state, that during his time he's running, calls back to the station, gets report on the existing warrants, the registration, all the rest. It takes a little while by itself. And I think the officer testified, a stop like this, maybe 7 to 10 minutes.
to complete on average, right?
Right, so if we use that as a benchmark, this thing really didn't overshoot that by much, even under the lengthier delay.
But the standard, as I understand it from Rodriguez, is whether the officer is diligent in completing that mission. And here, the officer was not diligent. He was.
Wasn't there testimony, though, counsel, that yes, he was on the phone with the MDA agent, but while he was on the phone, he was also waiting to get information back on the driver's identity, et cetera. So, I mean, he's doing two things at once. Isn't that sort of what the testimony showed at the hearing?
Well, that was the testimony, but the officer's testimony also included, and I brought this page of the transcript on page 165, where I asked him on line 17, so talking with MDA, particularly to Detective Ireland, and everything that's going on surrounding this stop prevented you from finishing the warning. Is that fair? And the officer's answer was yes. When you listen to that recording, they're talking about delaying this stop to bring the other officer over. The MD agent says right on the recording, well, have him sit, he'll have to wait. The officer's concerned that he doesn't have it. He says, in a minute here, I won't have anything. And they continue to wait for that second unit to come all the way across town.
But is there anything in the record rebutting the testimony that whatever their intent was, that as a matter of sort of objective fact, he was running the driver's information and waiting for that information to come back while he was having that conversation with the MDA agent? Is there anything that suggests that isn't true?
Yes, I mean, the quote I just read you from the transcript, he said the whole reason that he didn't complete the warning was because he was also talking to Agent Island from the MDA, which is not a part of a regular traffic stop for an obstructed, writing a ticket for an obstructed plate.
Can I ask you a slightly different question? Do you agree that if at some point, and I understand you may not agree with the if part, but if at some point there is reasonable articulable suspicion to believe that there's drug activity, then the stop could be prolonged enough to do the dog sniff? Do you agree with that?
If there was reasonable
I understand you wouldn't agree with the
suspicion.
if, yes.
Right.
So that's
then
why I
it could-
said if. Okay. So then does part of the inquiry become at what point is there reasonable suspicion of drug activity? Aside from the initial stop, whether there's additional information generated that would generate reasonable suspicion of drug activity.
Yeah, I agree that's a fair inquiry as to whether there was reasonable suspicion at any point prior to the dog being run around for drug activity.
And isn't that the difference between this case and Rodriguez? In Rodriguez, there was no inkling at all of any other illicit activity, whereas in this case, they had a pretty good sense that this may be a drug stop.
Well, I don't agree that they would have a pretty good sense based on the information that they had at the time, Your Honor. They had information from, I believe it was several months prior, from two CIs that said it was a black male, went by the nickname Hef, drove a white Monte Carlo. This was not a white Monte Carlo. The CIs said that there was going to be a delivery on a certain date. MD agents went and looked. There was no delivery at that date. And then they get information from an unknown source in Milo 2 days prior that...
Which is why there may not have been reasonable
Right.
articulable suspicion of drug activity alone to stop the vehicle. But once they identified Belony, don't they have reasonable articulable suspicion?
No, I wouldn't agree with that, Your Honor, because The nickname Hef, while it was associated with Mr. Belony.
Again, not beyond a reasonable doubt, maybe even not probable cause at that point, but reasonable articulable suspicion that this is indeed the name that of the person that they had identified as a Hef, and the person came, in on the bus, et cetera?
No, because there were several other people also that went by the name Hef according to the
Understood.
MDA, and the information that's just not only not corroborated, but in a way discredited, that Hef drives a white Monte Carlo, was the information they had. Not that Hef, according to the MDA,
From
came
Milo,
upon-
picked up by somebody else from Milo.
That was not information that they had, that he would.
Not
according
that
to
he
MDA.
would be picked up, but
Right.
they knew that the person who picked this suspect up was from Milo, or car was registered.
The driver of the car
Correct.
was from Milo. That
And
is
once
correct.
Belony is identified as being the person, the passenger in the car, and the DEA folks had intel suggesting that Belony, Hef, was going to be bringing drugs into the state, coming in on a particular bus at a particular date, and was picked up by somebody from Milo, that doesn't give a rise to articulable suspicion of possible drug violations?
No, not from an unknown source in Milo. It's somewhat similar to the Barcliff case that this court had decided, and I think there was probably even more information provided in the tip in that case than there was in this case. And all they simply saw was a black male getting off of the bus, getting into a vehicle that does not match the type of vehicle.
But that was on top of additional information that they had from identified confidential informants.
Could you explain that?
Well, the last one was from an unknown source that he was going to be on this person was going to be
Right.
on the bus. But with regard to Hef and drug dealing for somebody named Hef out of the Milo area, they had additional information that they had previously received from two other confidential, or from on two other occasions.
Several months
From
ago.
identified.
Right, several months ago,
confidential
and that wasn't corroborated, and in fact, uncorroborated when they said there was going to be a delivery and no delivery. And again, that information involved a white Monte Carlo, not a vehicle here. And the person that picked up Mr. Belony from the bus station, the record shows that MDA had, when they ran his plate prior to the stop, had no information about him being involved in drug activity.
Is the key to your unreasonable delay argument that segment, that 5 to 6 minute segment when Officer Libby's in the car having a conversation? If we took that out of the analysis, would you have anything to be arguing?
Well, that's the delay there.
Okay,
is that-
and
is
that's the
delay
whole
where he's, I mean, and I think the delay's clear from the conversation that they're having, that they're,
And I'll be asking the state's attorney, should we accept the time that the court decided the delay took, or the fact that everyone apparently agrees that it was longer than that?
all right, thanks, Your Honor. I see my time's up.
Thank you, counsel. Attorney Horn, we're happy to hear your argument.
May it please the court, counsel? First off, there were no anonymous sources in this case at all. There are 3 different confidential sources who were all known to law enforcement. The third one in time was handled by the Milo PD out there, but it was known to them, and that is in the record as well. So you have a known confidential source, not an anonymous one, which had given other information over time to them, told law enforcement that Belony, when this is also the same person that made the connection and identified Belony as Hef to them, that they knew Belony and Belony went by Hef, and was also closely placed to Belony, specifically through relationship with Belony's girlfriend, that he would be coming up on the Concord bus line that day with a load of drugs at a particular time, bound for Milo, which was mutually corroborative with the 2 other confidential sources who had previously provided information that he'd been bringing loads of drugs up to supply a trafficker in Milo. So as soon as Belony was positively identified, that's the point when reasonable articulable suspicion is crystallized and clear at that point.
When Belony is, I'm sorry,
Yeah.
you're
As soon as
protected. Go ahead.
Belony was positively identified,
Sorry.
there was RES. The agent suspected it might be him and pointed him out to assisting Officer Libby. They saw someone generally matching the descriptors of Jeff Belony specifically getting into the only vehicle at the whole bus stop that was registered to the Milo area. Was that reason enough to stop him yet for that? Probably not. However, Libby did see independently that it had a heavily obscured plate that was not readable and pulled it over for that basis. It was so coated with gunk that you can see one of the officers knock some of it off the plate to make the point on the video that's in the record. There's uncontroverted testimony in the record that an ordinary stop for something like that takes 7 to 10 minutes to process. The core complaint of the delay is that he called for backup and called Ireland on the phone and spoke to him for 5 minutes while continuing to run the driver's information, and that is the kicker. No matter how unflattering Ireland's commentary on the phone is, the record makes it clear that Libby continued to run the driver's information throughout that conversation, corroborated by the fact that he had Ireland on speakerphone, which would have left his hands free to continue operating the data terminal and everything else in the vehicle. The business of the stop was not interrupted. He proceeded diligently, notwithstanding any other conversation. And it's normal and okay to call for backup, like Donatelli. There were multiple occupants and there was a suspicion of drugs. Likewise, it's normal and ministerial to identify the other occupants of the vehicle under Fernandez. That is something that he did. Belony identified himself promptly. As soon as that happens, RES is completed, and that's about 7 minutes from initial contact with the driver. 7 minutes and some seconds. I see the light is green.
Do you agree that the trial court got the time wrong on the period that is at the centerpiece of the unreasonable delay?
I think it's articulated wrong what their court is measuring from, because it seems like the appellant and the appellee and the court are measuring from different waypoints, especially like in the appellant's brief, all of their times appear to be from when the video turned on, which is well before when the stop actually happened and when contact was made. So if you measure from the time he got in the car and started running, I think that's what the court is counting. It's about 6 minutes from when he got back in the car and then got back out and identified Belony.
So what does the state say the actual time was, the delay?
So by my count on the timestamps, there was cumulatively 7 minutes and 55 seconds measured from when he first made contact with the driver at the driver's side door to when he identified Belony separately. And included in that is the time it took him to get the license at the door in the first place, walk back to the car, have a 5-minute conversation, walk back to the other side, and get Belony's identification.
What do we have in the record that tells us exactly when the record check completed, as opposed to when the conversation with Ireland completed?
There are multiple spots in the record where Libby articulates that he is continuing to run the information while he's on the phone with Ireland. Respectfully, I think there's a difference of as far as whether or not he's going to write a warning slip versus continuing to run the information. And there's nothing in the record to contradict what he says that he continued to run him while he was talking to Ireland. Likewise, you don't see a backup officer show up on the scene yet, to my recollection, when he walks back up.
So in your view, do we take that whole 7-minute sequence and attribute that to the record check and the things he was doing otherwise related to the license plate?
I think it's fair to attribute that to multitasking, yes.
What do we do about the fact that the trial court didn't make any specific findings? I understand the argument that it's in the record, and I've seen some of the testimony you're referring to, but the trial court didn't actually make any findings about what Officer Libby was doing during that period. Is it appropriate for us to look into the record ourselves and say, well, affirm on any basis and there's record support, or is that beyond our purview?
I think the court can look at the record on that. I would agree that the findings here are a little bit thin as far as factual findings made in the order from the lower court.
Can I come back to that point? Because you mentioned earlier that it is a bit confusing as to when you start to count. But the court's finding was that Mr. Belony was identified within 5 or 6 minutes of the stop.
To that end, I would say that is probably erroneous. Like, if you're talking about when it pulled over to the side of the road, it's longer than that. I think the 5 to 6 minute, as I said, would be from the time when Officer Libby gets back into his vehicle, the door shuts.
I agree, but that's not what the court seems to have found. And one other question. Your your brief states, or it was somewhere in the record, that when Mr. Belony emerged from the bus, they focused on him because he looked similar, I think was the language.
Match the general physical description.
Yeah, on what basis were the officers making that observation?
And so at that point in time, they knew what Jeff Belony they were looking like. So they had, in fact, run him. So to that end, they have height, weight, skin color, hair, that sort of thing. And I would defer to the record for specifically how it was, explained. I think it was kept thinly to matching the descriptors. But to me, descriptors mean the vitals that go on your driver's license.
What do you think that, do you agree there was no reasonable articulable suspicion of drug activity, at least until Belony was identified?
I think there was a suspicion, I think...
Reasonable articulable suspicion, as that term of art is used.
I understand what Your Honor is saying. I think I answered that earlier, that I think it becomes RES for sure at the point that Belony is identified.
Correct.
Prior to
I
that,
understood that. And so do you think there was before that?
and I don't believe we argued that in our brief, and I think the court could choose to find that there was. I don't think it's necessary given the circumstances of the delay here, but arguably, and they did find somebody that matched the general descriptors of Jeff Belony getting off a bus,
I understand.
getting in a vehicle to Milo. So I could see a reasonable jurist finding that, but we didn't ask to go there.
Do you think that we can treat the court's error about the time within which Belony was identified, if we'd find that to be a critical fact, do you think we can treat that as harmless error? The court clearly erred about the time frame.
Right, and I know the court would be able to review findings of fact for clear error here, and I think we all agree there's some error, at least in how it is phrased on the paper. And I do believe it could conceivably be harmless because, again, we're talking about seconds, like less,
Well, we're
maybe
talking
give or
about
take
a minute or two or so, but is it your position that even if it, instead of being 5 or 6, if it's 7 or 8 or 9 minutes into the stop, that that's still good enough?
And I would say that's still within the zone of what a reasonable stop would take
And
for
that's
this
based
particular
on
offense.
the testimony you said that there was, in terms of how long a stop takes?
Correct, Your Honor. That's based on Officer Libby's testimony, which was not controverted at the hearing, that was a reasonable average window for that.
But if the judge got it wrong, do we, as the appellate court, have the prerogative to say, oh, he said 5 or 6 minutes, it's really 7 or 8, but we consider 7 to 8 to be, take your choice, an unreasonable amount or a reasonable amount? Is that our call in the first instance?
Well, at that point, it becomes a question of law, which is de novo for you, I believe. As far as that factual finding, that's clear error, and I think we're all agreeing that there's probably at least some degree of error as to that timing as articulated.
So we can reach a different result and say, yeah, 7 or 8 minutes, still within the reasonable realm, it's okay.
As I understand the law, I believe so.
What about the fact that the judge said that a seatbelt violation was not reasonable articulable suspicion? I mean, Libby told him that he wasn't wearing a seatbelt when they took off.
I think that was erroneous, frankly, especially when you underline the fact that he did make a finding, which hasn't really been challenged, that he didn't doubt the sincerity of what Special Agent Ireland said he saw.
Does that lead you to needing to identify the passenger as part of that violation?
It could conceivably, yes. I mean, if there was in fact a seatbelt violation, that would have a separate, completely different reason to identify the passenger. I mean, case law says that you can ministerially identify other passengers in the vehicle as long as it's not measurably extending the detention. And certainly this identification did not. He asked him for his name and he gave it pretty promptly at that point.
We've had some discussion about the testimony about how long a stop of this nature normally takes. Is that what we're to look at, or are we to look at the particular circumstances and simply what the officer on the ground is doing? In other words, if it normally takes 10 minutes to do a stop like this, but this officer wasn't doing anything in service of the original mission of the stop, it doesn't really matter, does it, with the normal?
I think you would have a completely different case if you had someone who was visibly twiddling their thumbs and not doing anything, waiting time to pass. Like that's not what we have here. If in that you did, then clearly they're delaying for no good reason at that point, and I don't think I could defend that. But here, at hearing, uncontroverted testimony is that he was continuing to conduct the business of the stop while he was talking to Ireland in the background. And that's normal, that's what he testified to. That really wasn't rebutted in any way. And again, the fact that he had Ireland on speakerphone in the first place is consistent with that inference.
Does that then bring you back to whether there's reasonable articulable suspicion of drug activity from the outset of the stop? We said recently in MacQuinn that, that in assessing, that when the duration of the stop exceeds what's necessary to deal with a mechanical defect, it's still okay if it doesn't exceed what's necessary to dispel suspicion of drug trafficking. And there we blessed 22 minutes until the dogsmith.
Right. I think this is a little bit different than MacLean, though again, as Your Honor has pointed out, I think a jurist could find reasonable articulable suspicion existed from the outset based on the combination of circumstances that existed, though I think it's more clear at the point Belony is definitely identified.
If the trained canine alerts on the exterior of a car, does that give the officer the prerogative to search everyone who's in the car?
So Harris and its progeny, nor any case I know of, squarely addresses that question. I haven't seen anything that addresses that. And I'm not trying to die on that hill today either, frankly. But I think under the specific facts of this case, here at that point, Belony's identified, so there exists RAS as to Belony as to drug trafficking. He's still inside the vehicle for whatever reason when the dog runs around the vehicle. The dog indicates on the vehicle, giving probable cause to believe that drugs are somewhere in the vehicle, right? And so they search the cabin first, and they don't find anything. So given that set of circumstances, by process of elimination, there's probable cause to believe that it's somewhere in the cabin. We've searched everywhere in the cabin but Belony, and we have RAS to believe that Belony has drugs. I think under this specific set of circumstances, it does give probable cause to search him.
I thought that's what we said in State versus Martin.
I forget, Your Honor, I apologize.
Okay.
Back quickly to the seatbelt piece. You said the court was in error in its finding with respect to the seatbelt being on.
I apologize, Your Honor, if I was correct. I'm not saying it was an error about it being on. I think it was an error to say that if you fervently believe what Ireland said, erred in thinking that there's not reasonable articulable suspicion to detain them for a seatbelt. We accept the
You can finish your sentence.
We accept the court's finding that he was, in fact, wearing the seatbelt.
Thank you. And counsel, I believe you reserve some time for rebuttal.
Yes, thanks again. I think Your Honor is right that it's the circumstances as to what the officer's doing during the stop and whether he's acting diligently or not to write this warning ticket.
Is there a problem with multitasking?
If it's causing a delay in completing the mission of writing the warning ticket, then absolutely, because that's extending the stop. And that's what Rodriguez says on page 357. How could diligence be gauged other than by noting what the officer actually did and how he did it? If an officer can complete a traffic-based inquiries expeditiously, then the amount is the time reasonably required to complete the stop's mission.
And that's true even if the activity is completed within the average time for a stop.
Right, because the officer's doing stuff other than trying to complete that ticket. And I don't agree that it's not controverted in the record that the officer was just waiting there for 6 minutes for some sort of inquiry to come back. I mean, you listen to that recording, it's obvious that he's twiddling his thumbs verbally, talking to the MD agent throughout this period of time. The MD agent says, just have him wait there. And they're waiting for this officer to come from across town, and he says, I'll go out in a minute and I'll get the passenger's identification. There's no talk about, well, I'm waiting for this to come back, or let me finish writing this up first. There's none of that. It's obvious what they're doing here. They're delaying the stop. And as far as the description that matched Mr. Belony, I think I can answer that question. He was black. That's why they thought it was Mr. Belony. There's nothing else in the record about him matching, to my recollection, any physical size of Mr. Belony or height or anything along those lines. And the delay wouldn't be harmless if you find the court erred the 5 to 6 minutes, which I think we probably all agree on, because it's actually closer to 9 minutes. According to the state's brief, it was 8 minutes and 48 seconds from the time of the stop to the soonest Mr. Belony would have been identified. So we have 8 minutes, 48 seconds passing there. No diligent effort to complete the ticket. These tickets can be completed in 7 minutes, according to the officer. So I think that's quite significant here. And as you point out, the trial court didn't make any factual findings that the officer was actually still in the process of writing the ticket during this period of time. I think you could review the record and find, based on the conversation he was having with Ireland, that he wasn't. And also, remember, we have the beginning too, where he delays it.
Don't we assume that when there's no finding and no request for additional findings, that the judge made the appropriate findings that are supported by the record?
Well, the court made no finding and no basis for its decision.
But isn't that implicit, is my point, that isn't that implicit in the judge's order, that he found he was doing whatever he needed to do until the time he identified Belony?
I don't think we can say that in this case, because the judge was incorrect in when he believed Mr. Belony was
Good morning, you can be seated. And the matter before the court is Cumberland 2584, State of Maine versus Jacob, also known as Jade Miller. We are being streamed on the web, both by audio and by video. I see counsel are present. I'm assuming you're ready to proceed. If you could identify yourselves by saying your names for the record, together with the party you represent.
Good morning, Tina Nadeau for Appellant Jade Miller.
Good morning, Kristen Hughes for Appellee, State of Maine.
Thank you. And Attorney Neto, if you're ready to proceed, we'd be happy to hear your argument this morning.
Thank you very much, and may it please the court. Unconsented to, unsworn, uncrossed, alleged facts are not inherently reliable. When there is no meaningful opportunity for the state to either establish their reliability or no meaningful opportunity for the defense to rebut or challenge those alleged facts, relying on them deprives the accused due process. The complaining witness in this case and her various versions of the facts are not inherently reliable. She is not an objective source. Similarly, the state retained expert whose conclusions were based in large part on the most egregious versions of what was presented to him by the complaining witness are not objective, reliable evidence, certainly not inherently so. And with that, I would take questions from the court.
Doesn't the sentencing judge get to determine what evidence or what information, let's put it that way, has been presented that is reliable enough upon which to base the sentencing analysis?
I think there's a limit to that, Your Honor. The evidence that they rely on has to be reliable, and I think that's where the error is here.
Well, there's an expert report that wasn't challenged.
It was challenged. It was objected to in the sentencing memo. It was not even referred to by the state in their recitation of the facts, and we were provided no opportunity by the court to challenge or rebut that
Did you
report.
ask for an opportunity? Did you have information? I mean, there's nothing in the record that shows what you would have done differently or should have done differently. In other words, you were at a hearing, and I understand you're now suddenly, and the state presented the expert report as part of their sentencing memorandum, correct?
Less than 24 hours prior to the hearing. Yes.
Okay, but you had it.
I did have it. Yes.
You didn't ask for a continuance.
No.
And I don't think you presented any contra evidence whatsoever, right?
No. And
Did you ask for an opportunity to cross-examine the expert or anything like that?
No, because again, the state did not rely on that expert report in their recitation of the facts in their sentencing memorandum in setting the basic sentence. So it was not clear to me, and certainly there was no time to gather up, I guess, resources
So isn't that
to
all
do
the
that.
more reason to ask for a continuance when you feel that you were surprised at the last moment by an expert report that wasn't mentioned in the sentencing memo?
Again, I did not believe the expert report was going to be used in setting the basic sentence. It was not something that the state had relied on in making their Huey argument in their sentencing memorandum.
Didn't the sentencing judge say, though, at the outset, when you indicated that you didn't agree with all of the facts as they were outlined, that you agreed only essentially with the facts as they were contained in the initial report? Didn't the judge indicate to you at that point that essentially give you warning that she would be deciding what the facts were upon which she was going to base their sentence?
She gave that warning, yes.
Is our review here for obvious error because there was no objection?
I don't agree that it's for obvious error.
Really?
If you feel that there is no objection, then it would be for obvious error. I think it does rise to that level. But I do think in both the memorandum and at hearing, appropriate objections were lodged.
If we did review for obvious error, how would we? What have you shown that would suggest that confronting the victim would make it reasonably probable that court would have found otherwise, maybe found only one incident of strangulation? I mean, right now it's a vacuum of what would have happened if these things took place.
I agree. I agree with that, yes.
So you can't really, you have no basis to say, well, if we were able to do this being challenging, if we were able to challenge, then this result would occur, because we just don't know the answer to that question.
I think we had a lot to work with if this case had gone to trial to challenge the complaining witness on the evolving, I think is a relatively objective word here, objective versions of events she presented.
Yeah, but
we
don't-
never had an opportunity to depose her or cross her, and none of her statements she ever made were under oath. So the only ones that we would consent to as far as reliability were the ones that I think have that indicia of reliability. Excited utterances in the heat of the moment, the freshest in her mind, the freshest in time statements
So those
she made.
challenges could have been made at trial, as you're pointing out. You had a basis to challenge. Were you trial counsel here?
Yes.
Okay. So you would have had these things to deal with at trial, but then coming into sentencing, where the same issues are relevant to the sentence, multiple instances of strangulation. But on appeal, you can't offer us to say, you can say we would have done this, but you can't tell us what the result would have been.
I can't tell you what the result is going to be. That being said, if they are not agreed to facts and they haven't been presented and challenged to an adjudicator, how is there a determination that those facts are inherently reliable?
Well, let me ask you this. So am I right, though, that right from the beginning, obviously you said we only agree to certain facts. The state was arguing right from the beginning that the facts were more egregious than what you were agreeing to, right?
Yes.
Okay, and it's sentencing too. So aside from what the judge found, I mean, that was the state's argument that the facts were more egregious.
Right. In their sentencing memorandum,
Yeah.
they incorporated, as I said, the various versions
The victim
of
was
events.
present by Zoom, I think, but nonetheless present
That's right.
at sentencing.
Yes.
Could you have asked to have her placed under oath once it was, I mean, it had to be apparent to you from the beginning that there was a dispute. That's why it was a triable case,
Right.
that there was a dispute as to what the facts really were, just how egregious they were. Could you have asked to place the victim under oath at sentencing?
In theory, but I've never been part of a sentencing where that's ever been done.
But essentially, my point is that as it went in, it feels like it was unrebutted. And so why is it not okay for the judge to then deem the facts contained in the information given to her as sufficiently reliable upon which to base, sentencing findings?
Just because I did not engage in this theoretical opportunity to cross-examine the complaining witness at sentencing.
Or present other evidence or whatever.
Present other evidence. This sentencing went awry when it became clear to me that the judge was going to find, as she did in her ruling, that things were inherently reliable that had been explicitly objected to, meaning there was and had been no questioning of that evidence, but the bare fact that the complaining witness said different things, that's fine. The bare fact that the expert report that was submitted as an exhibit relied on these various things, I guess that's inherently reliable.
You have a wide and lengthy experience in criminal defense matters. I'm going to ask you, are you aware of any sentencing in the state that took place where a victim was placed under oath and cross-examined at a sentencing hearing?
In the state court?
State court, yes, state court.
Not that I'm aware of.
But you are asking us to adopt such a rule, or at least make it more available?
I think State v. Dumont kind of opens the door to allow different things to occur. If a judge has a concern about the reliability of information, there can be procedures put in place. It's a non-exhaustive list. I think discretion is wide in this area.
Do you think
so
it
I
was
don't
up-
think it's prohibited.
Do you think it was up to the judge to ask to have the victim put under oath and questioned if there were disputes, or is it up to you?
It's a good question. I'm not sure. I think when the judge is in the position of fact finder, I do think it's incumbent upon the judge to determine what reliable information
But I mean, I
is
guess
there.
what I'm saying is based on how it was presented to her at this sentencing, she did deem that sufficiently reliable. So isn't it the risk that you take by not, presenting contra evidence in whatever format, in whether it's by witness affidavits, attachments to your sentencing memorandum, asking to have somebody placed under cross-examination, whatever the options are?
I will say the issues raised in Dumont and the other cases in my brief were not things that I was readily familiar with prior to following the sentencing. I didn't go into the sentencing thinking it was going to be a contested proceeding in the way that some of those cases either hint at or envision.
But the court did say at Rule 11, the Rule 11 proceeding, that she was accepting the state's version of facts and could rely on the sentence. I mean, I understand that Miller objected or stated that the agreement was only with respect to one of the multiple incidents, but the trial court did indicate that he was free to rely on the other instances. But I want to ask you this: does the same rule of reliability or principle of reliability that you're espousing here apply to step 2 in the Huey analysis as well? The facts that are presented to the court in step 2?
Reliability is reliability, and I do agree, and I think the case law is quite clear on that as well, that as long as information is factually reliable, agreed upon, or could be challenged in some way, then it can be relied upon in either aggravation or mitigation. Criminal history is one of those things, for example.
So what do trial courts do when they receive sentencing memoranda, as they did in this case, where both sides put in multiple exhibits, information? At step 2, you expected the trial court to rely on information you put in. How are you suggesting that there ought to be a second trial at that point, at the sentencing, as to the reliability of all the information put in?
The second trial, no, but I do think at step 1, when we're talking about objective facts and seriousness of offense, the reliability and the weight and the integrity of the information relied upon is extremely important. I do think judges are more adept at step 2 in looking at letters of, say, support or letters from victim impact to determine, people have certain interests, maybe this is reliable, maybe this is not. And I think they're more comfortable at that step in determining what's reliable and not. But to just accept the state's recitation, the bare recitation, whole cloth, is not appropriate, and it wasn't appropriate in this circumstance.
Thank you.
Thank you.
No, actually,
Oh, I'm
one last
sorry.
question. I'm sorry. And just help me out. When did you actually receive a copy of the expert report?
I received a copy of the expert report, I believe, in the fall of 2021. I think it was indicated in one of the footnotes, and Attorney Hughes was not the first counsel for the state on this. They had engaged with that expert to help present a superseding indictment for the charge of attempted murder. So that expert report was specifically tailored to that question. That was not something that had been generated or relied upon in determining whether or not to charge Ms. Miller with aggravated assault.
Thank you, counsel.
Thank you very much.
Attorney Hughes.
Good morning, Your Honors. May it please the court. Kristen Hughes for the state of Maine, Assistant District Attorney in Cumberland County. Appellee respectfully requests that this court affirm the sentence.
I see that you allowed the green light to go on
I did.
immediately. You knew going into the Rule 11 that the defendant agreed with a lesser or less egregious, if you will, recitation of the facts than was eventually developed in this case, right?
The state knew from the sentencing memoranda that counsel did not adopt all of the state's facts. However,
but you probably weren't really surprised by that. I mean, this is a situation where maybe with good reason, nonetheless, the story got bigger in the telling with each retelling, right?
I would disagree that it got bigger in the retelling in each retelling.
Well, it got bigger in the retelling, we'll say, at least at some point.
There was an initial report on scene, and then she received medical attention. There were reports there. Then there was a follow-up interview with a detective.
And one can explain why this happens in greater detail and all that, and we do this at trial. But my point being that you knew that from the sentencing memorandum that they were essentially in the Rule 11 going to admit to the facts from the initial report.
I suppose it was not clear to me that we were limiting the Rule 11 to just the facts in the initial report. That was not clear to me, and that was...
It became clear at the Rule 11.
Exactly.
I mean, it was clearly stated at the Rule 11.
Yes, it was very clear during the Rule 11 procedure, and I would...
Well, what did you give the court besides the expert's report that would constitute the kind of reliable evidence upon which a judge should base the more egregious facts that she found, i.e. 4 instances of asphyxiation?
Your Honor, I disagree with the premise of that question. A plea hearing, a Rule 11 hearing, is for agreed upon facts. When the facts aren't agreed upon and there's nothing to put on the record to rebut those facts that were laid out by the state, then it is in the court's discretion to decide what those facts are.
But it is. But doesn't the court have to have reliable basis to find the facts? And is a pure recitation by the state a sufficiently reliable basis to find those facts? I mean, we're not hearing. She didn't, hear from anybody else in terms of what the facts were.
The court does that every day in accepting every Rule 11 plea.
Well, most Rule 11s, where there's not such a stark dispute about what the underlying facts are.
And that's true. And I said to the court at sentencing that to dispute these facts in the way it was done at the Rule 11 hearing sounded like we needed to go to trial. But
that doesn't make sense. I mean, what they were admitting in terms of facts were definitely sufficient to support the charge. And, obviously the risks of going to trial are huge. So it doesn't make sense that one cannot plead guilty to a charge admitting sufficient facts to support the charge, but maybe not all of the facts. I mean, I've certainly presided over pleas where that was the case, not all the facts that the state was alleging.
Yes, but those pleas we're talking about minor facts, inconsequential facts, not facts that go to the heart and soul of the state's case. And that's what counsel and her client were denying as part of the Rule 11
But it wasn't
hearing.
the heart and soul. They admitted sufficient fact. They admitted essentially that there was an incident or there was at least one occurrence of asphyxiation. That's not minor. That's sufficient to support the charge.
It is sufficient to support the charge that in count 2. However, I would suggest that was never the entirety of the state's case. It was at the very beginning, but it was very clear from the spring of 2022, which is when the expert report was provided to counsel, April 4th of 2022, that this case was much more than just one incident. I understand that's what she pled to, but the case from April of 2024 until the plea and sentencing hearing date in this case was always multiple instances of strangulation.
But why does that make a difference? You're the defendant. You're at the Rule 11 hearing. You say, I agree. I'm pleading guilty because of these facts. I don't agree with those facts. And it's enough for the guilty plea. And so the judge says, okay, I accept the plea. Now you obviously, the state, have more facts that when it comes to sentencing, that you want the court to rely on in the sentencing. And the defendant disagrees with those facts. What's the defendant supposed to do?
When there's a disagreement as to the severity of the facts, and those facts are the underlying reason for the state asking for the sentence that it was asking for, I believe the correct response there is to go to trial.
Well,
she's already pled
no
guilty to as she should, because she's admitted to the crime.
And we all know there are some significant benefits in terms of sentencing to pleading guilty. One ought not to have to go to trial if one is willing to accept responsibility and is remorseful. That makes no sense.
But that's not what happened here. I understand.
Well, she did. She accepted responsibility for the count that she pled to. Don't you have to do something to show that the information you want the judge to rely on is reliable? I guess is my question, really. In other words, once it becomes clear that there's some dispute about what the facts are, don't you have some obligation to give the judge a basis to accept this version of facts over the other version of facts? And doesn't that have to be something more than you simply saying so, I guess is my question.
But that's not what happened here. That's not just what the facts weren't just what the state said so. There were, as part of the expert report that was provided, and the reason it was provided is because there are images of all of the injuries as a result of this incident. There is a recitation of the dangerousness from a medical perspective of a strangulation. There are explanation of the signs and symptoms of what Ms. Couric was reporting to the police that night, to her medical providers, and then in the follow-up interview. There are indicia of reliability.
Is the victim's testimony alone? If the victim testifies to other incidents, is that standing alone sufficient to ring the reliability bell?
It certainly is, because
Should the defendant have the right to ask that the victim's testimony at the sentencing be under oath?
Normally, testimony is not taken from a victim as part of sentencing. A victim
I know,
can,
so I'm asking if there's a dispute, whether they should have the right to.
I have done so, I will tell you, as a trial judge.
They can ask, but then that turns the plea and sentencing hearing process on its head. It turns the plea and sentencing process into a mini trial.
But it doesn't undercut the actual plea to the crime that was admitted. That's still, take a child's sexual abuse, the plea is to an incident that occurred on a certain day. Rule 11's through, it's to sentencing, and the victim testifies, yeah, there were like 5 other incidents on these particular dates here. That doesn't, putting that victim under oath to testify doesn't undercut the original plea, the original offense at all. That's still perfectly good. The issue is whether or not there were 5 other incidents, which would certainly raise the circumstances under step 2.
And arguably step 1.
And perhaps step 1
And
also.
step 1,
Yes,
yes.
right. But it's not new, it's not a new charge. It is something that is information for the court.
And I guess in that situation, similarly to this situation, the state was alleging a course of conduct. So the underlying basis for count 2 was that course of conduct over the course of the night of the multiple strangulations, which is, from what I'm understanding from the hypothetical, the same instance, that there was a course of conduct. And so that's why the court can consider that course of conduct in step 1. If the state had charged this case as attempted murder and then 4 or 5 counts of Class B aggravated assault, we would be before the court saying that the state overcharged the case and that all of those need to be merged.
Can the court consider those other things at step 2? Would that come in, do you think, at step 2? Is it appropriate for, this is kind of a side commentary, but is it appropriate at step 1 or step 2 alone or both?
It's certainly appropriate at step 1 if it's charged as a course of conduct. And if it's not, if there's only a single instance.
Yes.
So if the plea is only for a single instance,
Yes.
it would certainly be appropriate in step 2 to
Okay.
consider that. However, I do think that the case law is pretty clear, at least federally, that there do need to be indicia of reliability, because then that's considered uncharged conduct. And so that's where the distinction is. The distinction is, in step 1, we're talking about the charged conduct, the conduct that was pled to. In step 2, if the court wants to take into consideration other outside collateral information, like prior assaults or prior abuse, then there does need to be indicia of reliability for the court.
Are you saying that she pled guilty to strangling her 4 times?
That is the state's
Position, but are you
right.
saying that's what she pled to?
I'm saying that the court found that there were sufficient facts for.
Ultimately, it's sentencing, but as to what she pled to was what she articulated, correct, at the Rule 11?
That was their position, and the court found that there were sufficient facts for that version that she said she was pleading to, but also decided that because there was a factual dispute, that on step 1, the court needed to decide what and resolve that factual dispute.
Does this come down to the fact that there was, although clearly denying that these additional facts were true, there really was only one version put in front of the court, and that there wasn't any other evidence or suggestion that that wasn't, that undermined the reliability of that version, other than essentially a straight out denial?
I do believe that, and I think that the state would rely on the proposition, or the case of State v. Wright, WRIGHT, 588 A. 2nd, 1200. It's a 1991 case where the court said that the defendant had the opportunity to explain or deny the contested facts, and it was within the court's discretion
Well,
to
she did
consider
deny
those
them.
facts. Yes, but it was within her discretion to then, her ability to then explain them or explain why she was denying them
Right,
or contest them, and she did not.
Is it, that was going to be my question. Is it sufficient simply to stand up at a Rule 11 and say, well, I'll agree to the first part, but nothing else, without clarifying what it is that's an issue here? But in addition to that, in this case, the court went on to say, I want to make sure your client understands that if we proceed to the guilty plea and get to sentencing, that I will have the ability to make my own fact findings and might decide to accept the version of events the state just made.
That's correct. That is what Justice Lopez decided and put counsel and her client on notice that that would happen before proceeding with the Rule 11 so that she would have the opportunity to not go forward, fully understanding that the court needed to resolve the factual dispute.
But doesn't that suggest that Justice Lopez had accepted the defendant's assertion that they weren't agreeing to everything else, and so, but agreeing to plead guilty, and the court accepted that? It's now we're at the actual sentencing proceeding, and would the state have objected if there had been a request for the victim to be put under oath?
Yes.
All right.
Well, I would certainly ask for a continuance for that to happen because that's not something that we had ever discussed with the named victim in this case. And I think we could have done that. I would want to know exactly what the parameters would be of that cross-examination, and because at that point, I don't believe that a full cross-examination would be appropriate. I think a limited cross-examination may be appropriate if it had been requested. It was not requested. There was plenty of information in the form of the recitation of the facts, the victim impact statement, the recitation of the facts in the expert report, the photos that were included as part of the expert report that made it very clear that the court, that those statements had the indicia of reliability for the court to resolve the factual.
Let's assume it weren't such a sensitive issue, but it was something like, the amount of a restitution in a case that was due. And sometimes there are significant disputes about that, right?
Yes.
Isn't it appropriate at sentencing to have some testimony or other evidence submitted as a result so that the judge can determine what's the appropriate amount?
The mechanism for that is a restitution hearing. And so usually
Well,
that
it's part of the
occurs.
sentence, not a restitution hearing. But I mean, it is part of the sentence, though.
And maybe I'm incorrect about this, but my understanding is when there's a dispute about restitution, the court, as part of the plea and sentence, orders restitution to be part of the judgment, but then sets the case for a hearing to determine whether
Sure. So you
exactly
can
what
have
it
a
would be.
hearing on the amount of the restitution. So
Right.
that's a hearing in aid of sentencing. What's the sentence going to be?
There's also the opportunity in that instance to make an ability to pay argument.
I understand that.
Right.
But I'm talking about if there's simply a dispute as to how much was stolen.
Then I don't think we're talking about an agreed upon plea.
Well, we agree it was more than, $10,000, but we're disagreeing about whether it was 30 or 50.
Then yes, I think that there is the
You
the
can have a
process for
hearing is my point.
You certainly can.
So
Right.
to say that we don't have contested hearings as part of sentencing is my point is really not accurate.
I suppose I just have never seen it be part of sentencing, where there's an agreement to restitution, there's an agreement on the amount of the restitution as part of the sentence, and then the hearing is about whether or not the person has the ability to pay.
Right, but I think I've made the point.
Okay.
Thank you.
Thank you very much.
And for rebuttal.
Thank you. I would disagree with several things the state said, but one stuck out to me just based on our day-to-day practice, which is that a Rule 11 recitation is an agreed upon set of facts. It's not. If this case had gone to trial, the state would present evidence in the form of testimony, et cetera, to suggest or to prove this, this, and this. So it's not agreed upon.
Well, we can all agree, even obviously an Alford plea doesn't mean you may not agree with the facts, but even beyond that, we ask as part of a Rule 11 whether they agreed or not. And
That's right. And I think another question that's typically asked is not do you agree with everything, but Counsel, is that consistent with the discovery that was provided, meaning that we were provided discovery that, had the case gone to trial?
Especially in cases where a judge knows that maybe the facts aren't actually agreed to.
That's right. So I think, again, Rule 11 doesn't assume that all the recitation provided by the state is agreed upon at all, actually. I don't even think
But
that's
then the
common
question still
course.
is, whose burden, when you're going to argue about it, what is the burden to put in or to undermine the reliability? I mean, in this case, there was only limited information given to the court in terms of what the actual facts of the crime, as opposed to other mitigating or sentencing factors.
That's a really interesting question, because when we talk about burdens and criminal defendants, I start getting a little nervous. What is our burden to undermine the state's
Well, okay, I'll put it a different way.
recitation?
If it is uncontested, other than to say we disagree, can't a judge still find those facts reliable?
I think the state has to make a showing of reliability
But
for
it's
the
not-
judge to do that.
It's not a burden of proof at that point. You're contesting reliability.
Yeah.
And if you believe some of the facts are unreliable, shouldn't the defendant have the responsibility, I won't say burden, but to come forward and identify which of those facts? This was alleged as a course of conduct. There were a lot of actions other than just 4 discrete strangulations that happened here. So it's very unclear, I think, as to exactly what the defendant was not agreeing.
It was not initially charged as a course of conduct, and the charge that Ms. Miller actually pled guilty to was an aggravated assault based on the initial complaint of the complaining witness, which was 1 strangulation. 1.
But there were other things alleged in that complaint, I think, as Justice Douglas is. Besides, there may have been only 1 strangulation specifically mentioned, but there were other assaultive behavior. There was a whole course of conduct even on the initial.
In the 30
complaint.
seconds you have left, what, if you were to write the holding here, what would you want us to say? What would the holding be?
That if material facts are being contested in determining the basic sentence, the seriousness of offense, that the court shall, I guess, preside over or make a determination about how to determine whether or not those facts are reliable. So kind of the same open-ended approach hinted at in Dumont, which is there were things that the court could have done. I think we can reaffirm that here. And that the red flag for the court to note is when these very egregious facts are being contested, maybe it's time for us all to take a break and figure out a better way to do this than just your run-of-the-mill sentencing hearing.
Thank you, counsel.
Thank you.
Counsel, thank you for the arguments here this morning. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. And with that, we are in recess on this matter.
All rise.